Now there's a term down here, majority rules clause. The reason this was invoked is if you have two kids and they've been kind of co-executors, then the problem is if they don't agree, nothing ever gets done. Or if you have three, then what you could do is say, let's have a majority rules clause. If two of three agree, then we'll go ahead and do what we're going to do. So in the event you have two, it might not be a bad idea to have someone else kind of be the third person involved, and then you can institute this majority rules clause. Let me give you an example. You have a family cottage. You have two. One wants to sell it, one doesn't. Well, you know, it's kind of a complex problem. But if you had a majority rule where you had a third party, so two agree, the cottage is sold, the net assets would be divided up equally, and that resolves that whole problem. Now, why would there be such a disagreement about a cottage, as an example? Well, maybe one child goes there a lot and the other doesn't. One lives close to the cottage, the other lives on the other side of the country or in a different country. So you can start to understand the logic of that. And that can relate to an awful lot of issues, so it's a pretty valuable clause. Holograph will, very simple. And it is very simple because you can sit down on a piece of paper and write it out, and there's not going to be witnesses. Even you could have a witness if you wanted. But the problem with the holograph will is that it's easily challenged. So if there are complexities, it's not the practical will to make an English form will with a lawyer. But if there are very few complexities, I mean, the holograph will is quite okay. Just you probably don't have access to a lawyer because they would never agree that you do that. But if you've done a little bit of work, you can pick up one of these wills in Kohl's. You know, I think they probably cost $2 or $3. You just sit and do it on your own, but it just, you know, gives you a little bit of feedback on what you might want to be doing. Any will is better than no will, let's put it that way. This is a term that you'll come across on many joint documents. JTWROS, joint tenancy with right of survivorship. Husband and wife have GIC, or they have bank accounts. They're joint. Whoever survives takes over the account. Pretty practical way. Bypasses probate. It's a direct beneficiary. Very simple, not complicated at all, so it's a great idea. These items here we talked about before on the other videos, where somebody is going to do, you can make a trust, testamentary trust in your will. After you die, the trust will be created, or you could make a trust while you're alive. And let me just give you a simple example of who might want to do an estate freeze, which is basically an inter vivos trust. Government doesn't like these. They're taxed at the highest marginal tax rate. Somebody has shares in the year 2001 or the year 2000 in Goldcorp. They're trading in the $1 or $2 range, as an example. Well, 10 years later, they're trading at $50. So what somebody may do in the year 2000 is transfer those shares to their kids, whether, let's just say it's one child. So the person bought the stock at $1. At the $3 range, they transferred those 100,000 shares as an estate freeze for the benefit of their child. Now, what does this actually mean? It means that the assets from 1 to 3 would be taxed to the one that set up the inter vivos trust. Let's assume that's the parent. And then when the child gets the asset, everything from 3 to the $50 range would have been taxed to the child. So it's kind of like a tax division. You're trying to separate something that would face high taxation in the future by transferring that to a low tax recipient today. But as I said, the government's not very keen on these, and they are taxed at the highest marginal rate. Now these two items we've covered here. This item here, tax clearance certificate, is very important, especially for your executor on your estate, because until they get that tax clearance certificate, and here's what basically happens, although I've never had anyone tell me this, but we have to use some common sense assumptions, that when somebody passes away, government's notified, accounts are locked, until everything is verified. Safety deposit box, you need to get a court order to get inside, and I'm sure there's going to be some pretty official people there, because they fully expect if you have one, you probably have it for a reason, and it's probably not a good reason. Who knows what's inside the average safety deposit box. Something you want to check on, by the way, that I remember reading, that safety deposit boxes may not be covered by Canadian Deposit Insurance because it's an undeclared item. So you might want to check into that and see if it is in some areas and if it's not in others. I remember a famous story about some building that was considered to be one of the more secure buildings in the world, where a lot of rich people had safety deposit boxes and it got robbed. And there was a lot of cheering people. As you can well imagine, just figure out and do the math. So this certificate is that the CCRA is likely going to go online, and what they will do is look at all the years that you have been in Canada. Have you filed your returns? If there's blank years, they're going to demand that those returns be filed or tax be assessed in lieu of what should have been filed. And if the executor distributes assets without getting that certificate and then there's a shortage, they can hold the executor liable. So that in itself is worth it to understand the implications of that tax clearance certificate. Now, just quickly on one last item before this side of the tape is done. Probate is where your will has to go through a process and the government is involved, and a percentage of your estate assets will be paid to the government in fees for giving, probably stamping documents, verifying that things are done properly, and on and on. A lot of people believe very strongly in probate avoidance, and they are willing to pay to avoid probate. Sometimes they're paying more to avoid it than they are by doing it, but you know, human nature is human nature. It's like the people that will drive, spend $5 on gas to save 80 cents on a loaf of bread. Marriage and divorce. What's important here that a lot of people fall victim to is couples might separate and never actually go ahead and get their divorce papers filed. So, but under the law, they're still considered married, and that changes the entire structure of your estate plan from a legal point of view, because spouse has first claim on assets. Now, the amount varies between provinces, but that's an issue that's quite important. And when another thing about marriage is the day that you're married, all previous wills are revoked, and you should, in theory, you should make a new one, because you've got legal responsibilities now. And the same logic applies to divorce. And why? Because in your divorce, even though it is final, you may have legal responsibilities that you have to deal with. So, you know, you have to factor in all these things too. But anything that's kind of unusual in your personal situation, just highlight it and make sure you get proper advice on that. The term executor is pretty common. That's the one that's going to be looking after your will and your last wishes, and trying to make sure everything gets done to the best degree possible. I would think that anyone who was going to be an executor, if the government was being proactive, they would make people, when they get named, take a course so that they have a basic understanding of what's involved, because it can be quite an overwhelming task. Revocation is where you have a will and you decide you want to make a new one. Well, there's a couple of different ways you can do this. You have a will, you just make a new one, so in effect you are revoking your old will. In exchange, you're making a new one, so your old will would become invalid.